Ready? Okay, we're about to get started. Is everyone ready? Okay. My name is Jacob Hubert, and I'm Senior Attorney at the Liberty Justice Center. I'm joined today by Bill Messenger, an attorney from the National Right to Work Legal Defense Foundation. Spellings, my name is Jacob Hubert, that's J-A-C-O-B-H-U-E-B-E-R-T. And his name is Bill Messenger, M-E-S-S-E-N-G-E-R. Today we filed a lawsuit on behalf of 6 Illinois home caregivers and child care providers. For years, these caregivers were forced to pay money to the SEIU just so they could take care of some of the most vulnerable people in Illinois. Children from low-income families and people with severe disabilities. In 2014, the U.S. Supreme Court ruled that it was illegal to force these people to pay money to a union. But the court didn't address the question of whether it was right to allow these individuals to force these individuals to accept the union as their exclusive representative to speak to the state on their behalf. That's why we filed this lawsuit today. These caregivers were forced into a union against their will. They do not want to be represented by the SEIU, and they do not want the SEIU to speak to the government on their behalf. So we filed this lawsuit to protect their First Amendment right to freedom of speech and freedom of association. How did we get here? While he was governor of Illinois, Rod Blagojevich enacted schemes that forced 2 groups of caregivers into a union. The first group was people who provide home-based care to severely disabled people who receive a subsidy from Medicaid to defray the cost of this care. Typically, the person being cared for is a family member who's better off being taken care of at home rather than in a state institution. The other group the Blagojevich forced unionize is child care providers, thousands of them who serve children from low-income families who receive a subsidy for their care. As a result of these schemes, home caregivers and child care providers have been forced to accept a union, specifically SEIU, as their exclusive representative. So today, we filed a lawsuit in the Federal District Court in Chicago on behalf of a group of home caregivers and child care providers to end this scheme. It violates these caregivers' right under the First Amendment to decide what they will say to the government and who will speak to the government on their behalf.
Thank you. And as Jacob said, this case presents a fundamental First Amendment question. Can the government choose who speaks on behalf of citizens in their relations with government? Because that's what the state of Illinois has done here. The state of Illinois has designated the SEIU as the mandatory agent for tens of thousands of child care providers and home personal care providers for purposes of speaking to the government. In effect, the state of Illinois has designated a mandatory lobbyist to speak for these citizens. If we submit that's a right the First Amendment reserves these individuals, the right to choose who speaks for them and what organizations they associate with to lobby the government. In fact, what Illinois has done here is really turned democracy on its head. Instead of citizens choosing who represents them in government, here the government has chosen who represents certain citizens. We submit that violates the First Amendment and hope that the court agrees with our position. Thank you. There's the Harris versus Quinn decision from the Supreme Court that came out last year, and it held it was unconstitutional for Illinois to force home personal care providers to support the SEIU, because what the state and the SEIU were doing was taking money from all these home personal care providers, whether they liked it or not, and giving it to the SEIU to lobby the state and to engage in other political activities. The Supreme Court in Harris versus Quinn said that was unconstitutional, that the government cannot extend compulsory unionism beyond the workplace to a citizen's relations with government. And this case in many ways is a next step beyond Harris versus Quinn, which is to say if the government cannot support or cannot force these personal care providers to support a union to represent them before government, the government cannot otherwise compel them to associate with the SEIU. There's at least 27,000 providers each year in the home personal care program. Approximately, what is it, over 20,000 amongst the child care providers per year.
More like 50,000.
50, that's right, with the home relative care providers. It fluctuates each year. Some of those individuals are union members. However, those individuals can choose to voluntarily associate with the SEIU if they wish. Because that's really what this case is about, is freedom of association. Anyone who wishes to have the SEIU represent them, they're free to do so. The question, though, is for people who don't want the SEIU to represent them, can the government force them to accept a mandatory agent against their will? And that's what the state is doing to the tens of thousands of personal care providers and child care providers who are not members of the SEIU, forcing them to accept that union's representation without their consent. Well, they'd be individually representing themselves before government, because what these are government programs. So personal care providers and child care providers are not state employees. In fact, they're individuals who serve other citizens who are enrolled in public aid programs. So for example, a home child care provider runs a family daycare business. They sell daycare services to the public. Some of their clients, however, happen to pay with public assistance monies. So that is the hook to the state. It's just the fact they're serving someone enrolled in a public assistance program. And so what the union is doing is forcibly representing these individuals for purposes of lobbying the state over those public assistance programs. And so, but for exclusive representation, it would be the same relationship a citizen has with any other government program. They'd be free to decide who speaks for them in terms of lobbying over that program that may affect them.
I'll add to that a little bit. If we prevail in this lawsuit, these child care and home care providers will be free to support the SEIU if they think the SEIU will be a good advocate for them. Or if they think another union would be a good advocate for them, they could support that union. Or if they think another type of group that isn't a union would be a good advocate on their behalf, they could associate that with that group. Or if they'd rather just advocate for themselves, they can do that. That's what all of us do as citizens who are affected by government programs. We support groups that we think will advance the causes that are important to us, and if we want, we speak to the government on our own behalf ourselves. They're from all across Illinois, from the Chicago area and also downstate, all the way down to the most southern part of the state. So this lawsuit represents care providers all across Illinois. Since the Harris versus Quinn decision, the Illinois Policy Institute has heard from many caregivers who want to opt out of the union now that they're not forced to pay dues. They've told us they want help in opting out of the union so that money isn't taken out of their checks. And some of them also expressed interest in participating in a lawsuit like this one so that the SEIU wouldn't be speaking for them anymore. And so the Institute referred some of them to us for this lawsuit. And you know, they don't want the SEIU speaking for them, and they're also tired of being hassled by the SEIU. SEIU sends people out to these people's homes, gives people the impression that they perhaps are from the state to get entry into their houses. Sometimes they send teams of 2 people to pressure them into signing union cards, and these people are saying, we just want to be left alone. We don't want to support this group, we don't want this group speaking for us, and we don't want this group having special state privileges to come hassle us. We want to be done with this organization that we shouldn't have to associate with just because we provide for someone who participates in a government program.
Thank you. In terms of timeline, the case was just filed today. It's very difficult to predict. It just depends on the twists and turns the case takes. But we eventually expect this is a case that will make its way to the appellate courts and perhaps beyond. Thank you.